webinar. My name is Martin Roos. I'm Deputy Director of the Migration Policy Center here at the European University Institute, where I also coordinate the Horizon Europe funded Prime project, and I'm very happy to chair today's webinar. As many of you will be aware, today's webinar is part of a joint webinar series that brings together the expertise and the insights from 7 different ongoing Horizon Europe funded research projects. There's a little slide with quite a few logos. So these are all the projects. I'll mention them briefly. So there's the iClaim project, Dignity Firm, GAPS, FAIR, MIRIM, MORE, and PRIME. And today's topic is the legal rights of irregular migrants in Europe, which is part of the larger PRIME project. So I'm very happy to welcome the 2 co-authors of this new research, Clare Fox-Ruhs and Joakim Palme. I'll introduce them briefly. Clare is a part-time assistant professor at the Robert Schuman Center here at the EUI. And she has an academic background in law and a doctorate in social policy from Oxford. And Joakim has been a professor of political science at Uppsala University since 2009, where he is currently also the vice rector of the disciplinary domain of humanities and social sciences. And his research focuses on comparative studies, comparative welfare state analysis, from child policy to pension systems. I'm also very happy and grateful that we've managed to secure 2 discussants. We have Isabella Atanasiou, who is currently a legal officer in the asylum unit of DG Home of the European Commission. And prior to joining the Commission, Isabella has held various research positions in different countries, and she has a PhD from the EUI Law Department. And our second discussant is Martin Vink, who currently holds a chair in citizenship studies here at the EUI, where he also is the director of the Global Citizenship Research Area. And he's also the co-director of the Global Citizenship Observatory, and his background is in political science. So thank you all for joining us. And the plan is that we have about 20 minutes of paper presentation, followed by a few minutes of remarks by Isabella and Martin. And then we'll have opportunity for Q&A with all of you. We have quite a large number. There's over 60 people online. So if you have a question, please write your question in the chat box, and I'll read it out afterwards. So without further ado, we'll go to the presentation. So over to you, Claire, and I'll start sharing the slides.
Thank you, Martin. Good afternoon, everyone, and thank you so much for joining us today for this presentation and for discussion on a topic which we think is very important and relevant in today's world, on the rights of irregular migrants. So today's discussion and presentation is based on a paper that Joakim, my co-author, and I wrote with the help of many others in our Prime project, and it's on measuring and analysing the social and labour rights of irregular migrants. It's about new indicators across 28 European countries. So we'd like to thank very much our colleagues at Uppsala University and the University of Zagreb for their contributions to the data collection and the early analysis and design of this project. It's been funded by Horizon Europe as part of the broader, as Martin mentioned, Prime project protecting irregular migrants in Europe. So please have a look online at the full paper if you haven't already done so. So the starting points for the discussion today, we start from a point of interest in the conditions of irregular migrants across European countries and how those conditions might vary. We have concern for the vulnerability of migrants and exploitation in the labour force. And we want to understand more about the picture of irregular migrants' experience. And as part of that analysis of conditions, we are particularly interested in the role of rights. We think that rights have an important relationship on conditions. Rights empower individuals. We have an idea based on a kind of concept of capabilities developed by Sen that rights enhance freedoms and they enhance individuals' access to resources. So we want to explore that further. And we have certain expectations that rights might vary across European contexts. So we know as a starting point that rights are always contested. They're always politically contested, and that goes for the rights of citizens and the rights of non-citizens. And as a result of this political contestation around rights, we already know that there are differences in rights across countries, across European countries for citizens. So in particular, socioeconomic rights, which have implications for the redistribution of resources, such rights, vary already across countries, and hence we have different welfare state arrangements in Europe. And the same goes for labour rights. We have different labour market regulations across European countries. So not only are these rights of citizens politically contested and determined, but they're also then structurally and institutionally shaped. Over time, the welfare settings and the labour market settings that have played a role in the rights of citizens influence what we have today. And one of the questions we had was, well, how do these different settings across welfare states and labour markets in European countries impact on the rights that irregular migrants might receive, the rights of non-citizens? Do we see patterns that follow from the rights of citizens, or do we see something different? So that was an exploratory question that we had, and we have a particular concern in understanding how the irregular status of migrants might impact on rights. So we have an hypothesis that there's always a goal conflict for countries. On the one hand, they have a requirement to regulate borders and control immigration and manage immigration. And on the other hand, they have already established publicly commitments to fundamental human rights to all persons on their territory. And that results in something of a conflict for governments in how to meet both fundamental rights protections on the one hand, and on the other hand, regulating immigration. So if we can move to the next slide, please. So to start this project, we had to begin to conceptualize the legal rights of migrants. So how would we try and understand how irregular migrants' rights are protected across European countries? And our starting point is with rights in law. We felt that this was a good basis for analysing rights, looking at what the laws of European countries provide for irregular migrants. Now, by irregular migrants, we mean all migrants who are in a country without the legal right to reside. And we exclude from that migrants who have particular protection statuses, for example, those who have come to seek asylum and are treated as asylum seekers, those who have received, let's say, a protected status because they're victims of trafficking, or those who, for various reasons, may not be able to be returned. They may be unsuccessful asylum seekers, but cannot be returned for different reasons. These groups of people, these groups of migrants, all have different types of protected status under the law. So we're focusing solely and exclusively on those without a protected status who don't have the right to reside. They may have entered legally and their visas may have expired. They may have entered illegally. So many reasons why people are irregular. And our concern, as I said, about rights is about capabilities and the impact that rights might have on people's lives. So while we look at positive law, we're looking at legal rights, the rights in law, we're also very much interested in the quality of those rights. So how do rights enhance individuals' capabilities? We look at 3 dimensions of this. We look at the adequacy of the right, and by that we mean that rights have differences in scope, and they have different benefits associated with them. So we look at this question of adequacy. We think that the adequacy of legal rights for irregular migrants should be judged against the rights for citizens, because we have certain standards in countries that are deemed to be appropriate for citizens, and we judge the adequacy of the right of the irregular migrant against the right of the citizen. Another aspect of whether a right enhances capabilities is associated with user costs of those rights. User costs relate to accessing services that might have a particular access cost, certain types of healthcare and education in some countries. And again, we measure, we think that the quality of a right depends for a migrant on whether the costs of that service are equal to those of citizens. Then we look at the dimension of agency, and agency is really, as we see it, about individuals' freedom to actually exercise rights that they might have on paper, their legal rights. And so again, the question there for migrant is how free are they to exercise the rights that we have in law? So I didn't mention here, sorry, on this slide, we've also got the box around coverage. And by coverage, we just mean, is there a legal rights provision or isn't there, and who's covered by it? I can talk a little bit more about that when we talk in the next slide on indicators. So thank you, Martin. We have these different dimensions of rights. This is how we conceptualize rights. And then we have to think about, well, if this is how we see rights and conceptualize it, how could we actually measure this across countries? And we use those dimensions, the core elements that we see as constituting legal rights, coverage, adequacy, cost, and agency, and we measure them. We measure them against different indicators. So to measure the coverage of a right, we look at the population, the irregular migrant population that is actually covered by the legal provision in that country. So that might be, for example, the whole population, anyone who falls into the category of being irregular as a migrant, or it might be limited to irregular migrants who've been in the country for a certain period of time, for example, or irregular migrants in particular situations. So we look at coverage. We look at also then, when we ask the question about adequacy, we're looking specifically, as I mentioned, about the scope of the benefit in relation to a similar benefit that a citizen might get. So, for example, if we're talking about the right to primary care, does a migrant have access to the same type of primary care that a citizen would have, or something less than that? Again, costs, the question there is, if you're going to be charged for a service, is the charge that migrants are charged the same as the cost of citizens? And agency, we measure against two indicators. One, which looks at legal aid and which asks, do migrants have access to legal aid if they want to enforce their rights? And we look at the other element, which is very important for migrants, which is whether a migrant can access a service or enforce a labour right without the risk of being deported to the immigration authorities, without the risk of being reported to immigration authorities. That's important because obviously risk of being reported might bring with it the risk of immigration detention and potentially deportation. So these are the indicators that we use. And we score these indicators, could you just go back to the last slide, Martin? We score these indicators on a scale of between 0 and 1. So for every right in our data set, and I'm going to show you a table of the rights that we cover, for every right in our data set, we measure them on these 4 dimensions. They're scored between 0 and 1, 1 being here a right that is either full coverage or full adequacy in relation to at the same level of a citizen, or costs and agency, for example, at the same level of a citizen. And then we add those together and we take the average of them and we come up with an overall score for each individual right. And then we build our indices by adding together these different scores and taking the overall average. The details of the aggregation are available in the paper. I'm afraid I don't have a lot of time to specify, but we can talk about this more in the discussion. So if you could move to the next slide, Martin, please. So the method, in order to make this analysis of the different indicators, we basically analyzed, as I said, national law. National law is composed of statutory laws. So we look at laws on immigration, laws on labour, laws on social security, human rights laws, equality laws. We look at national constitutions, and we also looked at case law. So the full range of legal instruments in each of the countries that we look at. And we also devised a particular bespoke data collection instruments so that we were taking exactly the same information for all of the countries for each of the social and labour rights that we measure. In order to validate our data, we cross-checked countries between the different teams who were involved in this. And as I mentioned at the outset, we had a team of researchers at Uppsala University and a team of researchers at the University of Zagreb who helped in the data collection across all European countries that we covered. If we could just move to the next slide then. So this gives an outline of the actual rights that we measure in our analysis. We have 16 social and labour rights. As you can see from the table there, we've got 4 healthcare rights, 2 education rights, and 2 social assistance type, four social assistance type rights, so 10 in total, sorry. Social assistance being those of the emergency variety, income support and emergency shelter, and those of the kind of routine variety, more mainstreamed income support and social housing. And then we have got 6 labour rights that we look at, which range from minimum wage, recovery of unpaid wages, and then standards in the workplace, health and safety, working hours, compensation for workplace injuries, and we also look at the right to join and form a trade union. So in these 16 rights across 28 countries, we conducted our analysis. If you could move to the next slide then, Martin, please. So as I mentioned, each of those 16 rights that you have just seen is scored across the 4 dimensions of legal rights: coverage, adequacy, agency, and costs for those rights that have costs. These are the results across all of our 16 rights, as you can see in front of you, for the score on coverage. So as I mentioned, 1 indicates a higher score and 0 a lower score for coverage. And the rights that most European countries of the 28 that we look at protect for irregular migrants are emergency healthcare, maternity care, back pay, and health and safety at work. And then if you go to the other end of the scale, the rights that are least protected are minimum income support, housing support, and also the emergency varieties of those: emergency shelter, emergency income, subsistence support, and further education and training. And then somewhere in the middle, we have a bunch of labour rights and some healthcare rights. And the reason why coverage isn't 100% in some of those cases, for example, in maternity care, is there may be aspects of that care that not all migrants will be eligible for. So not the entire population is covered, whereas you can see the only right across the board where 100% of the irregular migrant population is covered for in all countries that we look at is emergency healthcare. So if we could move to the next slide, we can talk then about the way in which those rights are protected in law. So one thing that we were very attentive to was to recognise that not all legal protections are explicit in law. Some may be implicit. And by that we mean that the rights on the face of the legislation might not actually specifically mention irregular migrants. They might talk about the rights of all workers or the rights of all employees, for example, on labour rights, or it might be the rights of all persons, or the rights of the uninsured, for example, when it comes to healthcare. So we take account of this when we are when we're looking at when we're analysing rights, because for us it makes no difference whether a right is implied or explicit. If the individual is able to enjoy that right, it carries the same weight. It just requires a detailed analysis of making the determination of when a right is implied. And as you can see, it's quite difficult. There's a lot of information going on here, but if you look at the overall columns that show the labour rights and social rights, and if you look at implicit rights, you can see that there are large proportions of rights that are implicit as well. In fact, explicit provisions are in the minority, explicit exclusions also, and many rights, particularly labour rights, are implied in law. If we could then move to the next slide, we looking at the second dimension of rights, which is about adequacy. And I think that there's a very simple message on this slide. As you can see in these long bar lines, what we see here is that when rights are actually covered, when migrants are covered in law by a right, typically the right is provided on the same basis as citizens receive. So adequacy is typically good, exceptions being the very, very minority of countries that offer any form of housing support or guaranteed minimum income. If we could move to the next slide then, we see a different picture when it comes to costs. So the healthcare rights and the education rights, which have potential user costs across countries, those costs are not always the same as the costs to citizens. In most countries, the right to access to compulsory education for children is provided on a free basis, but not in all countries. In some countries, irregular migrants may have to pay, and that cost may not be the same as, maybe unequal to those of citizens. And then if we look at other forms of healthcare rights, you can see that really in just around 50% of countries, if we take the 4 types of healthcare, emergency, primary, maternity, and specialized, we're talking about just under 50% of the countries that we look at who offer healthcare rights offer those rights on an equal cost basis to citizens. And this is significant because costs may be a major obstacle for irregular migrants using rights, even emergency healthcare or any kind of necessary care. If we move to the next slide, then we also see that when it comes to agency, unlike adequacy, where we saw the full, well, a lot of fuller bars across the screen, we see here that actually we're looking at scores of less than 0.5 for most rights, with the exception of further education and training, which is an outlier, given that very few countries actually offer this right to irregular migrants. So most rights that are offered to irregular migrants either have some form of reporting restriction or they do not offer legal aid to irregular migrants to enforce those rights. So if we could move to the next slide. This gives you an example of the countries that offer what we call firewalls. Firewalls being firewalls are where essentially a service provider or a government authority is prevented by law from reporting irregular migrants to the authorities. And they insulate irregular migrants so that they can exercise rights without that risk of being identified and potentially detained and deported. But as you can see, we've only got a handful of European countries that offer those firewalls. The Scandinavian countries stand out in this list, as does Italy for healthcare. We have a number of countries actually that have the reverse, which actually require service providers who give rights to irregular migrants to report those migrants. So we've got there Bulgaria, Portugal, and Estonia. If we could move then to the next slide. This takes those 4 dimensions: coverage, agency, adequacy, and costs where relevant, and gives the overall scores for the rights. And again, we see a similar pattern as we saw in coverage, with healthcare, back pay for unpaid wages, and compulsory education at the top, and the income support and housing rights at the bottom of the overall rights score. And I'm conscious of time, so if we could move to the next slide, Martin. I want then to explain to you a little bit about the country scores. So not only do we analyze then the rights that are most and least protected and the quality of those rights, but we look at the different rights scores that each country gets when all of the individual 16 rights are added together and divided. Then these are the scores that come out. And we see 4 different groups of countries emerging in this analysis. We've lettered them here, A, B, C, and D. So the countries on the left side, A and B, are those countries where migrants have fewest protections, and the other countries, C and D, where migrants have most protections. And those in C and D, protections typically span labour and social rights, and they also typically would have fewer costs that are equal to citizens, and some rights that where migrants have either access to legal aid or maybe insulated from being reported. So a mixture of things. And what you can see in this across these countries and this categorization is that the question that I posed at the beginning, do welfare state settings across European countries and labour market settings tell us something about how those countries will go about protecting the rights of irregular migrants? Well, I think you see a mixed pattern here. There's no obvious grouping. So, for example, whilst in the top group we have 2 Scandinavian countries, Sweden and Finland, with universal welfare states and medium labour market protections, we've also got, the universal welfare state of Denmark down in Group B. Quite a few differences. Another example we could pull out there would be, for example, Malta, which is a higher performing country based on our analysis, and would have a liberal welfare state. Poland, there also in Group C, maybe against some expectations, is scoring higher than we might expect given labour market settings in those countries and welfare state settings. So there's the bottom line is there is not an obvious pattern in welfare state settings, certainly, perhaps a little bit more in labour market regulation regimes, and that's something that requires further exploration. If we could just move to the next slide now in summary. So In summary, there is a core set of rights that are protected in a widespread way across European countries. They've been mentioned. Labour rights are better protected than social rights. And there may be some spillover effect from countries that have high labour market regulation and medium labour market regulation relative to countries with lower labour market regulation. And we infer this also from the fact that rights are implied in significant numbers. So rights are drafted in terms of all employees and all workers. Migrants are benefiting a lot from those types of rights. Where legal provisions exist, adequacy is usually quite high. However, the big however in all of this work is that, how meaningful are rights in terms of migrants' capabilities if there are barriers in terms of costs and if there are barriers in terms of being able to exercise the rights without the risk of deportation and detention. There are no firewalls for labour rights in any European country. So final conclusions. It's obvious that there is a goal conflict across all European countries. Governments are balancing this in different ways in terms of the fundamental rights that they offer migrants and in the immigration controls, whether that's via reporting or whether that's via kind of barriers related to cost to try and reduce the numbers using public services. The Employer Sanctions Directive at the EU level very much encourages both rights on the one hand and controls. And the question is, do they cancel each other out? How effective is this actually? The Employer Sanctions Directive has brought about almost complete coverage across European countries of the right to back pay. But the question is, how many migrants are using that right if associated with the right, there is the risk of being deported and the risk of being detained via this reporting mechanism. Also, what scope is there for EU action on the area of basic subsistence support for migrants? So migrants who are in acute need, those who are at risk of homelessness or are homeless or with, at risk of poverty, what measure is there in the future? And what more can we do in terms of research, but to understand the dynamics behind these differences across countries? And what are the roles of the different institutional settings, welfare states, constitutions, courts, regional governments? Sorry that I've run over by a number of minutes, but I'll hand over now to our discussants for their feedback and for further questions.
Great, thank you very much, Claire, and we'll go straight to Isabella.
Thank you very much. Thank you very much for the interesting presentation and also for the work. I mean, needless to say, it's obvious to everybody, this is a very solid piece of work. It's very well grounded and with a good methodology. So I'm not going to delve too much into that. Congratulations for the work. Now, the comments that I have are more or less from the perspective of someone who is a practitioner interested in these topics. So, for example, one of the practical, let's say, comments that I had is I understood that you excluded from the scope of your study those irregular migrants who are not returnable. So you mentioned that they enjoy a specific protection status. Now here I have a little bit of doubts. I mean, are you sure about that? Because I was not aware that this is practically the case always. And what I wanted is also to make a little bit of a qualification. I know that you looked only into national law, so you didn't look into the impact and whether there is a practical impact or not of the European legislation that is relevant on this matter. But as you know, there is two categories of irregular migrants under the return current directive and the proposal. So first of all, countries in the EU currently and under the proposal for the reform of the rules on return can be excluded from the scope of the return rules of the EU if the member states so wish so for the irregular entries. So people who entered irregularly can be excluded from the scope of those provisions. Now, why am I saying this? Because in a paradoxical way, if you are excluded from those pieces, the scope of those pieces of legislation, you are also excluded from the scope of the protection that those pieces of legislation offer to the irregular migrants. And I'm referring here in particular to the so-called obligation to provide for basic needs, which is the bottom line of all of it, but at least that is guaranteed by the directive and the future proposal for the return, whereas irregular migrants who have been taken out from the scope of these pieces of European legislation by the member states perhaps do not have this guarantee. So I was wondering if you have any reflections or information from what you came across on this particular point. Then I had a remark that was a little bit triggered by the table with the ranking of the countries from the high level of protection towards the lower one. In the higher categories, I found Belgium, for example. And what came to my mind is the fact that indeed I can understand how Belgium is considered a country that, at least on paper, when it comes to establishing rights, because they have a non-discriminatory approach in their law, can be considered to be very protective. So in other words, implicitly, including irregularly migrants, may have, in theory at least, access to certain rights because the law is comprehensive, does not discriminate according to status. However, I wonder if this is indeed the case in practice. I mean, I don't want to pick a fight against Belgium here, but I mean, the idea is that many of you probably know that Belgium is a country that has a very, very restrictive policy when it comes to regularizing people who are not returnable as well. Maybe you remember that a couple of years ago, there was a massive demonstration of irregular migrants in Belgium. There were hundreds of them who actually went on hunger strike for weeks. It was really very dramatic. So the situation of those people who have been for decades in a irregular situation in Belgium shows how tight the policy when it comes to regularization is in that country. And I find it a little bit of a contrasting thing, you know, between being on paper comprehensive or non-discriminatory and the fact that these people are never regularized, which brings me to question the issue of the possibilities for enforcement. And this perhaps relates to the question of my colleague Federico as well in a certain way. For example, if you cannot really claim your rights in practice, is it sufficient to have them on paper? Now, I was wondering, my question for you is, when you created your database, the information from your sources covers real possibilities of enforcement, let's say, or is it only a theoretical estimate based on what is put on paper in the law? I don't know if it is clear, the question. And I have a clear example in that respect. I mean, one of the rights which I consider myself basic, and it's inspired by the asylum field, but it applies also to other people in different status or other situations, is the right to have documentation. If you have been for a long time in a country in an irregular situation, you may come very easily, presumably, to a situation where you no longer have papers, neither from your country of origin nor from the country where you are currently in an irregular situation. Now, if you do not have documents, do you really have access to those rights which are stated on paper as being comprehensive and available to everyone? And this right to documentation, I think it is part of what you call social rights, not the economic ones. And I was wondering if you came across some kind of information about this aspect as well. And then what I wanted to say, and then I would close with this thing, perhaps just one remark about before the final point. You are talking in your paper about access to education of the children of irregular migrants. I think that in a certain way, there is no room for maneuver. That's why you see it scoring high, because there is the UN Convention on the Rights of the Child, and basically it is guaranteed by the International Convention. So it's not a matter of status. All children have to go to school, full stop. On your last table with no, not the last, one of the tables that you had, there was this ranking of the social and the economic rights in terms of, how should I put it? If I remember correctly, the number of countries that actually apply them or not. No, it was a graph like that. in that graph, what you have at the very bottom, you know, housing, those kind of rights which are more restrictive, are, as a matter of fact, what is considered basic needs under the Return Directive. So this to me is an indication that many of the people who are covered by these kind of surveys are actually probably not even benefiting from the minimal protection that is offered by the European law. You see? This is what I'm thinking about. And then the last remark that I had is perhaps more political, so don't take it as representing my employer. It's a personal remark. You know that in the European return rules, the current ones and in the future ones, there are remarks about people who cannot be returned and should not be left in a legal limbo. I think that in the current directive, there is an encouragement or a recommendation not to leave people in a legal limbo, but it is not an obligation under EU law. In the proposal, obviously, this sort of like fades away. The times that we are living in are impacting the context of what is going on in terms of legislative proposals. But I think that this is, at least from the perspective of somebody who works for an European institution, I think it is the point of my personal interest to see the impact that we have and how far can we reach in terms of ensuring rights and minimal rights for the people through our legislation. So maybe for future work, not for the current study that you are having right now. And I would leave it there.
Okay, fantastic. Thanks so much, Isabella, for this really interesting comments. We'll move to Martin now.
Yeah, thank you. Good afternoon, everyone. And first of all, compliments to Clare and Joakim, the authors of the report, with a great report. My comments come mainly from the academic perspective. I've been studying immigration and citizenship policy comparatively over the last couple of years. And I know the literature well, and there has been a lot of work already for the last maybe 15, 20 years on constructing indices of migrant rights, of immigration policies, and also of citizenship policies. For example, I see that in the audience, one of our colleagues, Samuel Smith, is there, who has worked on an index in the area of citizenship policy, the Citizenship Regime Inclusiveness Index. And so I very much welcome now this edition on irregular migrants' rights, right? Which I think is really important. I suppose the issue of it, the saliency of it is varies across countries, but it's certainly across Europe a really important topic to study. And yeah, I also applaud the authors for taking into account the accumulated wisdom from all the work that has been done in this field by having in the report, if you read this, you will see that there is very clear conceptualization, clear ideas about transparent coding, and also clear aggregation rules. So in that sense, I think this fits very nicely with the existing literature. I have comments on 3 points. The first is on the data availability, then on additional elements that you might include. And the third question is more on, so what question, and maybe moving towards explanatory questions. So the first point is data availability. So I would like to know, and maybe the audience would also be interested to know, if the data underlying the report is already available. And if so, if also the original sources on which you base the coding will be made available. Because I think in our field, it is really important that we accumulate knowledge, that we avoid redoing work, and other people may be interested in similar kinds of work. So I'm sure they would benefit a lot from all the sources that you have accumulated across the project. I know that in the report there is a large annex which indicates the kind of questions that you ask, but it's also important how this is, to see how this is applied in particular cases, right? Both for replicability, but I think also for people who, like myself, who may be interested to play with the data and get going with this. And this may, making the data available may then also feed into the project perhaps while it is still running. So I would recommend making the data available, if this is possible, as soon as possible. So the second point I think in your measure, you have already a very comprehensive approach to rights coverage, right? And so I think this is very good, but inevitably there are things that are missing, right? I saw that one of the people in the chat already asked whether the right to make complaints should not be included. And since I work on citizenship, I wondered to what extent you have considered looking at access to citizenship, and I'm thinking especially for about the children of migrants with an irregular status. I know that in the report you refer to children, right, the right to education, but my impression is that overall the focus is more on adults than on children. But there are, of course, increasingly more countries in Europe that apply territorial birthright policies where children born in a country may have right to citizenship, but often this is conditioned on the resident status of the parents, right? So in Germany, this is, for example, 5-year residence, and typically this will be regular residents with a regular status. But for example, in Portugal, I think this is the exception. A child born in Portugal will have a right to Portuguese citizenship if the parent has been there for 1 year, even if they have resided there with an irregular status. This may actually disappear soon from the Portuguese law because the current government is, I think, planning amendments on this, but would be interested to know more about citizenship. And then thirdly, yeah, I think I would be interested to hear more about your ideas about the big picture, right? So I think one big picture that comes from it is that there is a lot of variation, right? And I think this is clear. But Claire, you mentioned this in the end of your presentation that, of course, you start the project also with certain expectations, right? And especially the question of why do rights vary across countries and across these different dimensions. Now, I know that in the report you are saying explicitly that this is an important question for the project, but you're not dealing with this explicitly in the report, right? But you do include some teasers, let's say, right, at the end of the report. And I would encourage people to look at that. For example, in figure 13, you explore the relation between welfare state regime and irregular rights extension, right? And I think your hypothesis is that there may be a trade-off, right? You could imagine that a country that has not a very strong welfare state, in that context, it may be easier to give people rights if they come with less substance, you could say, right? So in that sense, I think there could well be a trade-off. But in the very tentative exploratory analysis that you now do in the report, you see, if I read this correctly, no relation, right? And so I would be interested to hear, how do you interpret this? Does this mean that maybe your indicator doesn't cover everything that there is, right? Maybe there are concerns about implementation. Should you, in this exploration, you now use more aggregated indicators, but maybe you should use disaggregated indicators, and maybe the relation with coverage will be stronger. Maybe it is about political change, since actually your report at the very end also shows that there has been quite some change over time. And welfare state regimes, of course, are supposed to be more permanent. So if actually this turns out to be subject to political change, then by definition, the correlation would be less. And yeah, finally, actually, I heard this question, you post this yourself in the podcast that you're doing. So I would recommend people to listen to the podcast that is on the Prime website, where Clare and Joakim are interviewed, where you also bring in another trade-off about giving rights to irregular migrants and how they affect the rights of other migrants, right? So you could imagine a situation where maybe a regime prefers to give all migrants at least some basic rights, but then the level of the rights will be lower. Or we say, well, we prefer to give higher rights to those with a regular status and are maybe somewhat less concerned about people with irregular status. So did you find any maybe qualitative evidence that such trade-offs exist? Okay, thanks, and congrats again with a great report.
All right. Well, thanks so much, Martin, for this excellent comments, and also for the very helpful advertising of some other Prime products, the podcast. In the interest of time, I suggest that maybe Joakim and Clare I mean, if you can't respond to everything now, but just a quick respond, kind of 1-2 minutes before we go to some of the questions that have been posted online. And I'd encourage the online audience, if you have any questions, please do write them in the chat. We'll come to them after Joakim and Clare have had an opportunity to respond briefly. So I don't know who wants to go first, Joakim or Clare. Joakim.
Okay, thanks, Clare. Thanks for presenting the paper in such a coherent way. And just quickly, I mean, we are capturing what is legal here. It's not a practice. So it may well be that the sort of rights that some countries have on paper are not matched by a reality of actually giving access to irregular migrants across the board. And that's another part of the PRIME project, to investigate that, at least for a handful of focus countries. But it's our ambition here to cover rights that have a remedy. So without the possibility to legally claim the right, we have that as a precondition for assigning a country a specific right. What is pointed out here when it comes to the sort of basic provisions stated in European law, I mean, and also the point about the rights of the child in the UN Convention. This is not enough for us to show that there is a right. We need to have some legal documentation in the specific country. But I think that it's a good starting point for discussing the obvious gap that we have identified in certain rights. And you pointed to this emergency housing and emergency benefits as good examples here. When it comes to Martin's points here, I just want to say that they're very useful. We, of course, will make this data available in about a year, and they will be made available, including the sources in the what's called the MIGPOL framework. MIGPOL is a migration policy database that is part of a bigger platform for making macro policy indicators and macro indicators at large available. It's called DEMScore. And for anyone following the work of PRIME, will give you the links, of course, in due course. And I think we are in the middle now of trying to explore the kinds of issues that you raised, Martin. I think your points about you know, that there may be different kinds of trade-offs, but there might also be different kinds of spillover effects. And I think what we see here is maybe not a zero correlation, but we see that some countries with generous welfare states seem to be also generous to the irregular migrants, but not all. And also some countries that are perhaps not as generous, that are generous to irregular migrants, suggesting that there are other mechanisms of sort of reaching generosity. And I think Clare has identified a number of such mechanisms linked to the role of constitutional courts, etc. So thank you for very useful comments.
Thank you, Joakim. Clare, anything you want to add at this stage?
Maybe one point to pick up from Isabella about basic needs. So I think this is a very important point that you mentioned in terms of the Returns Directive and basic needs. And it kind of has a parallel for me with Article 3 of the European Convention. So protection against inhuman degrading treatment. So to what extent can we use these provisions around basic needs and, you know, the prevention of inhuman degrading treatment as a mechanism to access the tangible things like a bed for the night, shelter when there's acute need, or, you know, minimum subsistence support, and who can get this? And I actually do think that there is scope here at European level for doing something more on this, and maybe honing in on that point that you mentioned, you know, where are the gaps in those directives? How are they applying and why are they not applying? And when we mentioned that we're looking at those without a protected status, so it's not necessarily it's not that we're excluding people who have failed in their asylum claims and can't be returned. We're excluding those who are recognised as having failed and then therefore have been in the country for a long time and have that protected status, like the dual-dung status. But there are obviously many others that don't have that protected status and are in this protection gap as we talk about it. And also just to Martin, yeah, Joakim picked up that last point. I think you're right that we need to explore further some of these relationships. I think the court aspect has been very significant. So there are no indicators out there on interventionism, judicial interventionism in this area that we could reliably use at this point, but maybe we could develop something that's there. And I think that it's really interesting to look at how interventionist judiciaries have been working within existing systems to provide protections. For me, a classic example was the French Constitutional Court, you know, relying on you know, the French Constitution, over 200 years old, to defend the right to legal aid for irregular migrants just last year. So courts have played a very important role, and we also believe that regional governments are playing a very important role politically. And that's something that's not captured, but we do look at regional variation, and a way to expand the index would be perhaps to look at how within countries there is significant regional variation. And so devolved countries are of particular interest in this respect and might cast a different picture. So thanks so much for the comments. And we take any other questions. Thank you.
All right, thank you, Claire. We've got about 10 minutes left, and Claire and Joakim, if I can both ask you maybe to also look at the chat. I'll just go over some of the questions in the chat, and then you can come back with some comments and responses. So the first issue I think that Federico Birocchi has asked from DG Home is this question about whether you should also measure where's the right to make complaints. I think you've already partly addressed that, and we've also had actually an online response from Alexander Kiselov, who is at Uppsala University, who's been part of the research team, who's been responding online. And then Rainer Bauberg asked two questions. I think both of them are important that would be useful to get some responses on. One is he asks regarding firewalls, whether you only checked firewalls in national laws or whether you also looked at legislation at provincial or local level. So I think that's important to clarify. And then a later related question, whether you also looked at the right to regularize, particularly permanent. So a second way of acquiring rights, I suppose, is to regularize. If you could comment on that. We've got another question from Paul. He asks, presumably these results are from 2024 legislation. Are there any plans to update this work? And there's also a question about the question from Jordanos suggests that you've kind of focused on the supply side, which I understand is the kind of legal provision side rather than the demand side. So what about the in practice? What about the language skills, different awareness levels, in practice differences between individuals in terms of their ability to access rights? There's a question about whether or not rights don't differ between different purposes of moving as irregular migrants. And yes, I think that's if you could respond to some of these questions. Sorry, there's one more question which I want to read out, which has just come in from Rachel Rodriguez Camejo. I'll just read it out. Hello and congratulations. I'd like just to make a comment about my own experience as an irregular immigrant in Spain. I spent 4 years in this situation. The most frustrating thing for me was all related to legal exclusion of people with this migration status. I couldn't borrow a book from the library with my passport, open a bank account, or even study at the university. And the reason was always the same, the migration law. Thank you. So Joakim, and again, you can't respond to everything, but if you could reflect briefly on some of these issues.
Will you start, Claire, and I can fill in?
Yeah, I could start just clarifying the point about firewalls. Yes, Reiner's question, we looked only at national law legislation, and that kind of reflects also the overall focus of the work, given that the rights are in national law. So the firewall was, is it legislated for? Because we know that there are other means that migrants get rights. the discretion of local authorities. And again, the discretion to use firewalls, but we didn't look at discretions. And that is something that we capture and we have noted, but we didn't measure them and score them when we did the indicators, because we wanted to distinguish between a right and a policy discretion or policy practice. But I think it's a very important point and something that we need to think about for the future. Regularization is again something that we have looked at, and we have a separate project on that, mirroring similar methodology to what we have used here in terms of indicators. So we're currently exploring this area using indicators of regularization. And the hope is that with the similar methodology, because we're looking only at the right for individuals to regularize, and we're hoping that we can look at that and see what patterns, if any, there are between countries that offer the right to regularize and the different conditions that they attach to that right and the different opportunities for regularization, alongside this more like a la carte rights-based approach as opposed to regularization. So I think with, you know, when that work is available in the next number of months, the next 6 months or so, we can compare those two things. I'd like to thank also the comment about in Spain about the kind of lived experience of irregular migration. And I think that raises other important social rights like the library access, the access to university, and gives us some sort of food for thought for expanding the index in the future. And the same to the question about time frame. Yes, this was looking at laws up to the present day, up to the time at which we were doing the analysis, but there is of course scope to update those, and things are changing rapidly in this field, changing for better and for worse for irregular migrants. So that's certainly something that we hope to expand and keep this data set now running, now that we have established it, to try and improve it. I'll pass to Joakim now.
And I can also add that we've tried to capture changes sort of backwards and asked coders to report on any legal changes in the recent future, and that gives us some ideas of the direction of change, which is not unidirectional, it goes in slightly different directions. But I would also argue that when we make these data set available, including the sources, it will be much easier to update the material for us, but also for others, because I think the sort of procedures are established, and that makes it possible to follow up for the future. Thank you.
All right, fantastic. So we've reached the end of this hour. So I would like, well, first of all, to thank the two speakers and co-authors, Clare and Joakim. I also want to say a big thank you to Isabella and Martin for taking the time to read carefully the paper and for your really helpful comments. And I'd like to thank everybody online for attending. We've managed to retain an audience of 60 participants. So I think this is pretty good for what, at least in Italy, is a very, very hot afternoon. So thank you all. I also want to say that this video will be a video recording of this discussion will be online, and there's also a YouTube channel of all the projects with the handle HE Irregular Migration if you want to see some of the other webinars that we've held in the past. So I'd encourage you to take a look at all the project websites of the various projects, and please stay in touch. And thank you again, and have a nice afternoon. Bye-bye.